Okay. Last class we discussed about the authors, owners, copyright in the form of statutory rights, and and registration procedure, and we are aware of the various rights of copyright owners. Okay. There is another part that I have not kept within the purview of copyright modules, just like say another rights. Let's discuss little bit on that part. Sometime we call related rights or neighboring rights. Okay, what is that? Okay, just like say broadcasting right. I have not kept it. Broadcasting and performer rights, broadcasting rights and performance rights. Okay, that will come within the purview of related right or neighboring right. Okay, neighboring right. So what is that? Let's say some games. One entity is doing broadcasting operation. So they have a right with reference to the broadcasting. Similarly, that acrobat, musician or singer, dancer, they are performing with reference to some song or some cinematographic film or some dramatic work. So they have the rights also. Their rights called performers rights. Okay, and these are treated as neighboring rights or related rights. So they are also right like the copyright. They have also right just like in the form of positive rights. They to reproduce their performance, to copy their performance, to transmit their performance, just like to transmit, to broadcast, and to transmit. All sorts of rights have been provided to them in the form of related rights. Okay, so this is sometimes we call copyrights and related rights. So if I ask what is the rights of ESPN with reference to that IPL or Sony Max, so they have the right for broadcasting. So they can broadcast. If some other person try to use that thing, they have to take license or permissions from the that organization. Okay. Similarly, that if I ask that you know that Kaun Banega Crorepati, Amitabh Bachchan, that performing that part, if somebody try to copy his performance, he is considered to be an infringer with reference to the performance rights of Amitabh Bachchan's. Okay, so this is the coming within the purview of related rights. Okay, so what I try to mention here, I use two words we already discussed in respect to patents also. One is right, another is infringement of right. Okay, the owner has the right, and the infringer means who without permission and authorization of the owner violate the exclusive rights of the owner. So if somebody violates the exclusive right of the owner, he will be treated as an infringer, and his acts will be considered as infringement of right of the copyright owner. Okay. So now say I discussed already that infringement of infringement is reference to the patent, just like a direct infringement, then indirect infringement, just like say in copyright context also infringement occurred directly or indirectly. Okay. What do you mean by direct infringement? Already referred. If you copy or somebody's work, then it comes direct infringement, or if you induced infringement, just like say Sony Betamax case. If you analyze that case, just like say that Sony created a device. By virtue of that device, somebody may copy some copyrighted work. So, the device is facilitating the infringer to do infringement, to perform infringement. Okay. So, then Sony is treated as facilitator for infringement. So, in that case, the whether Sony will be liable for infringement. So, in that context, we may consider secondary copyright infringement, or say another part we call vicarious liability. Inducement or procurement, by virtue of that so secondary, so primary infringer means who is say just like who with that device is downloading or copying the copyright protected work of others, he is the direct infringer or primary infringer, and Sony is facilitating to perform that infringement. Sony will be liable for that term called secondary infringement. Okay. Infringement. So, that lies the issues called primary infringement, secondary infringement. Similarly, you may consider that Google is, let us say, putting lot of copyrighted work in their in their sites, or in their service provider, they are putting in their websites. Or now, if somebody just like if I consider whether Google is facilitating or YouTube is facilitating to somebody to commit infringement, in that case I may put the Google or YouTube as liable for infringement under the purview of secondary copyright infringement. If somebody facilitating, inducing infringement will be treated as a secondary copyright infringement. Okay. In respect of soft, just like I am discussing any within a short time before going to discuss about another important issue for your the students, that is fair use. But before fair use, you should know what is not fair use. Okay. Just like say for that reason I am discussing with reference to the term called infringement. Okay. And that infringement, and within the infringement fair use may come as a defense. So, fair use is not per se your right, but fair use you may consider defense, but situation to situation specific. Okay. So, now that infringement means violation of the statutory rights of the copyright owners. Here also two types of infringement: primary infringement, secondary infringement. Nowadays tertiary infringement, all sorts of things have been coming up based on that inducement theory or facilitating theories of infringement. Okay. So, primary infringement, secondary infringement, just P to P sharing, you understood, peer to peer sharing. I will discuss that part with respect of digital media and copyright elements specifically. Okay. So, so understood that infringement is coming by virtue of violation of the statutory rights. Now, how the infringement will be judged? So, the test adopted for infringement. So, one is somebody is copying, or copy part should be considered substantial copying, substantial copying. that will be decided case to case basis, substantial, whether the infringement is, there is a copying, two way he is doing copying, infringing the work of the let us say plaintiff or the owner, he is copying, let us say copy means exactly copying, or he is substantially copying, let us say substantially copying. Okay. So, if he copied or substantially copied the copyright protected work, he will be considered infringers. So, substantially will be decided based on the situation to situation, and he should if he copied the idea or some element, sometime we call sins a fieri or sins a fieri or idea expression, identity kinds of situation, just like say temple can be expressed in a singular way. So, those kinds of situation will not come within the purview of copyright, or he copied that method, just like say Baker versus Sheldon case. Somebody has written the book process for bookkeeping, and somebody utilized reading that book, he kept the book in the library. So, he has performed the work what have been stated in the book. So, that procedure is not come within the purview of copyright. So, he will not be treated as an infringer. Okay. So, that copyright part infringement if copy and substantially copy of copyright protected work lead to the infringement of copyright. Okay. Copy and substantial copy will be decided based on the case to case basis. Okay. So, you understood, you should not copy substantially depending upon the situation to situation. Okay. So, now let us discuss about at your technical grade the software copyright and software copyright infringement. Okay. Software, say let us say that source code and the say structure sequencing, say software source code will come within the purview of copyright. Okay. Let us say consider software source code is coming within the purview of copyrights. Okay. So, a copy of the source code, if I presume that software source code is only coming in the purview of copyright, then copying of the source code lead to the violation of the copyrights. So, in that respect of copyright infringement, one important case is there in US jurisdiction, we call it computer associate versus Atlai computer case. Here the situation is very interesting situation. A employee was initially working in one company, later on he is working in a particular platform for development of a software, later on he shifted the organization and work in another company, that another company is also created a software similar to the his parent company. Then they try to investigate, based on that they found out the person has joined in that company, then the issue arises with reference to that copyright infringement. In that case they came up with a case called AFC, abstraction, filtration and comparison test. So, they try to find abstract the different elements of the software, they filter the non copyrighted elements of the software, then they try to compare the softwares of the plaintiffs in the company 1 and company 2. If they found substantial similarity between the softwares of plaintiffs and defendant. Plaintiffs means the person who filed the suit, defendant means against whom he filed the suit. If they found substantial similarity after comparison of those elements, then it will be treated as a software infringement of the software copyrights. So, what is the test? Abstraction, filtration, comparison test. Abstraction of that software into different element and sub elements. Okay. And then filtration means which are the not copyrighted protected elements, maybe structure sequencing of the software, okay, or sequence of the software. So, if something is coming in the form of idea or expression identity, something is coming in the form of sins a fieri, those are not come within the purview of copyright elements. So, non copyright elements will be filtered out from that, then the filtered that sometimes we call filtrate is coming within the purview of copyright protection. That filtrate will be compared to judge the substantial similarity. Then substantial similarity if judged, then it will be considered copyright infringement. And will judge the substantial similarity, then sometime we call lay observer test. A lay observer will judge the substantial similarity. Lay observer will judge the substantial similarity of the two work. Okay. So, now before discussing of the actual content of this this class, I have discussed with you that one important parameter we were supposed to miss, that neighboring rights, and another important parameter that is coming within the scope of this class specifically, because I am the scope of the class is copyright and fair use, but before learning the fair use, you should know what is unfair use. Means what is unfair means that coming up in the form of infringement of rights. So, infringement of rights, that violation of the statutory rights of the copyright owners will be considered as infringement. Infringement may occur by virtue of let us say in the form of primary infringement. Infringement may occur by virtue of say secondary or vicarious liabilities kinds of situation, and so inducement and procurement kinds of situation. And also we have discussed the infringement is just based on copy or substantial copy, and the test adopted is called substantial similarity, and substantial similarity is judged by the lay observer. And with reference to the computer program, the test adopted called that adopted in America called abstraction filtration comparison test, and for musical work they adopted test called melodic reduction test to judge the substantial similarity between the two works to judge the infringement. Okay. So, now what you understood now, what is let us say unfair in respect of copyright that lead to the violation of the statutory rights of the copyright owners. Now, let us say copyright is somehow have been say creating with respect to literary work a knowledge domain. So, copyright is providing knowledge to the different persons. So, in that case copyright have created a provision called fair use. Okay. So, fair use, if you use the work protected by copyright in some cases, that will not be considered as infringement of the copyright work. Okay. So, Act has created provision for that something will be considered come within the purview of fair use, not use in the purview of infringement. In that case, these kinds of use, even you do not require permission from the authors. Okay. So, the what is fair use have been provided in our Copyright Act by virtue of section 52, that fair use they have provided the different types of use that come up in the purview of fair use, just like a use for private use. What do you mean by private use? Something is not public. What is public? Communication to the public. So, some cases may create, let us say you are using some copyright protected work for private use. Means I can give an example. Let us say a television channel is say just like say television channel every day they are just like this particular serial they telecast. Okay. Time to time they telecast, and you are recording those serial, and ultimately out of that you have created a CD. Okay. And if you use that CD out of those television serial and use those CD only for your home purpose, then you may consider that is use in a private use. Okay. Not, you should not use that CD in a club, in a fair, and you should not, if you copied that CD in a multiple way, then your intention should be not private. So, if you use that CD, made a copy of, made a one CD out of that, and maybe you will be considered maybe that private use. Then use of some copyright protected work for research purpose or non-commercial purpose, criticism or review purpose have been considered as fair use. Okay. If you use somebody's copyrighted work and use it for criticism purpose or review purpose, then will be considered as fair use. Okay. Sometimes somebody asks that, okay, I have say use some copyrighted work and given the reference of that source, whether I will escape the liability of copyright infringement. Some cases they refer that mere acknowledgement is not sufficient, you should take permission from the owner of the copyrights. Okay. So, understood. If you there is another concept called plagiarism in academic context. Sometimes we call in academic context a plagiaricus or kidnapper. So, if you copied some work and treat that as your own work, so you will be treated as an abductor or kidnapper or plagiarius or a plagiarizing. Okay. This is also considered a serious academic offense. You should remember, this is treated as a serious academic offense or academic offense. So, to escape liability of this academic offense, you should give the source, okay, from where you are using that particular expression. Okay. That is called to avoid plagiarism. Now, for copyright infringement, you should take permission from the owners of that copyrights. So, sometimes people ask that, okay, if I copied only 3 page or 4 page, whether I will be liable for copyright infringement or fair use kinds of perspectives. So, in respect of say few jurisdiction, they referred say 20% copies or something, but now if you come to US part, how they consider the fair use concept, let us read that. Okay. The US statute, the statute does not clearly define fair use. Just like India, they refer these sorts of use is stated as a fair use, but US they have not told that these what will come in the fair use, but they have created the few factors to consider the fair use analysis. The factors are that the purpose and character of the use, what purpose and what is the character of the use, okay, and the nature of the copyrighted work, what is the nature of the copyrighted work, the amount and substantiality of the portion, amounts and substantiality of the portion copied, the effect of the use upon the potential market for or value of the copyrighted work. So, you understood what I was trying to mention, that okay, whether 20%, 40%. Now, if you analyzed with reference to the US copyright law, they are telling effect of the use upon potential market. So, you understood, if you copied maybe a small portion that is affecting the potential market, means let us say primary market or secondary market, that is different issue, potential market, or deteriorating the value of the copyrighted work, you understood, that may not be treated as fair use. Okay. So, so fair use is not a like a specific use in USA, but they will be decided based on the factors like a purpose and character of the use, nature of the copyrighted work, amount and substantiality of the portion relation to the copyrighted work as a whole, and the effect of the use upon the potential market or value of the copyrighted work. Okay. So, you understood that what will be considered as fair use in respect of copyright specifically. For for the students and researchers. Okay, let's analyze that, taking a few example. Okay, so let's say you have say created a folder. That folder contain new song, new movie song, and if that folder is only available your personal computers for your personal use, then that may be treated as private use. But now if your computer or PC, if you shared in a network, and now that everybody can access that folder also, folder is not in a by not protected by any security key, then it is not be treated as a private use. So you may be liable under copyright infringement. Similarly, let's say you have created something, downloading different software from different components. So now if you create if you just now create a folder to keep that software, and if you now sharing that folder means of Facebook, WhatsApp, mobile app or some other ways, then you are not say doing the act whatever we call fair use. So you will be liable under copyright infringement. Okay, so now with respect of computer program, what is fair use as stated in the Indian Copyright Act? Let's read that provision. So for making copies or adaptation by copies purely as a temporary basis, let's say so if you create one copy for so in respect of damage and destruction, so considering that part for checking for interoperability purposes and others, purposes and others, so that sorts of things or copy should not be considered a copy by on the purview of copyright infringement. So in research and analysis purposes, making a copy for repairing purposes or for the respect of storing that thing for repairing purposes, for that purpose may not be considered infringement for infringement of copyright computer program. For you can make a copy of the computer proprietary computer software for let's say to protect it from damage, destruction or repairing purposes, then that will be come within the purview of fair use. Okay, fair use. So, okay. Similarly, let's say in respect of teachers and people for the course of instruction, just like say teaching purposes, I am using some material may come within the purview of fair use. In the course of instruction may come up within the purview of fair use. Okay. So say private use, fair use. Okay. Research use, fair use. Instructional for the instructional purposes use may be treated as a fair use. And non-commercial use definitely treated as come in the purview of fair use. Okay. So like if I now ask a questions to you, let's say say orchestra party is performing some songs, or that song is song and a musical composition of a particular musical composer protected by copyright, then whether that will be come up within the purview of fair use or copyright infringement. Just like say version recording, sometimes we call version recording. So version recording, copyright infringement or fair use. So just analyze that type of situation in respect in the context of copyrights. Okay. So for the students learning part, what is copyright infringement, what may come within the purview of fair use, what is plagiarism. All those elements are the learning point for you and is very important for the students specifically. Thank you.